Lawyers of Reddit, what's your best most bad as I rest my case moment? As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spring chicken himself and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92 and the case has already gone on for 5 years, the judge was visibly shocked and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt/runoff issues. Mr. Smith, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness, I'm aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraphs 6 to 10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read, but could you put this passage in your own words for the court? Witness, these are my own words. I wrote it. We were the defendants. We were being sued by an hoa over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake elsewhere. However, that site was owned by a very large corporation and I don't think the hoa wanted to fight with an entity that could fight forever. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. No, Your Honor, I never speed, was his reply. The judge asked him a couple more times if he was sure if he never sped, ever. The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding, the driver had to pay medical bills for my sister. So I call up my client's disgruntled former employee about a contract dispute that he started, and that got my client into litigation. After 2 questions, it was obvious he was a lying son of a beach. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents, and which cast my client in a false and bad light. I did not tell him how it caught him in lies. Fast forward one day, I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the lying sack of shit. Fast forward to trial. My opposing counsel calls the lying sack of shit as his first witness, and the lying sack of shit acts like a lying sack of shit. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract, the party suing did. After the lying sack of shit left the witness stand, I asked the court for a brief recess. Granted. I approached opposing counsel. My client was still willing to sign on to the walkaway settlement, where no money changes hands and no fault was admitted. We offered the deal 2 months before, and it was angrily rejected. Now, suddenly, it was accepted. Score. I'm relatively junior, so in hoping to beat this one day, I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the element of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said jokingly, well, of course it's fine when we ask for it. A lawyer friend of mine had written a blog post about a legal subject. Opposing counsel filed a motion again. As others pointed out, this is like the small battles which are part of the overall war of the lawsuit in which they had to cite their reasoning for their arguments. In this particular motion they chose to dig through the website of my friend, where they found that blog post which they chose to cite in their own arguments. Basically, they were going for an aha moment. You can't argue against us, because you yourself once wrote something which we think agrees with our point of view, rather than dispute the nitty-gritty details of their argument. My attorney friend simply responded with something along the lines of I'm honored to be cited as an expert in this area by my esteemed opposing counsel. Now, as their chosen expert, let me tell you what the law means, and why they are wrong. It was glorious. They very quickly revised their argument. Not a case winning moment, but a motion winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that ruler meant they could do X. I tried, multiple times, to point out ruler literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said show me where rule says X. Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said judge I have nothing to add. It was pretty fun. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, first thing he told me was to tell the truth no matter what. He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table, like I was Vincent LaGuardia Gambini, hands behind my head, and say, I'm done with this guy. I was on the losing end. Represented a guy who had bought a company and the company failed spectacularly within months due to a number of reasons I could attribute to the seller, and they had clearly lied about the company's finances to induce him to buy. I was suing to rescind the deal, have your shitty company back, and give my guy his money back. I laid out my huge case and thought I had it in the bag, and then opposing counsel asked my guy, isn't it true that you listed this business for sale a month ago? Yes. And you did sell it, correct? You signed a purchase and sale. Yes, but he never finished paying me. He has more payments to make. I'll just give his money back. When you guys give me my money back, my idiot client had me suing over a company that he had legally sold. F never told me. Game over on the spot. I do mostly solicitor work, so if I'm doing my job right I don't get a whole lot of these type of moments. That being said, I had a long time client who was being sued, and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete/confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out, or he can find himself another job. He takes the latter option. But he starts a lawsuit against the owner, wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation, and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. I'm not an attorney, and it wasn't in front of a judge, but I got into a dispute with a contractor who ducked up royally when installing a new heating system, resulting in an asbestos contamination of my house. Their insurance argued the contractor couldn't have caused the contamination because the contamination was way worse than could have been possible from what the contractor did, which is bullshit. They argued the contamination must have been caused by the contractor that installed the previous heating system. It was super satisfying to write our response. 1. The previous heating system was placed 12 years earlier. The asbestos dust was visibly lying everywhere. Arguing we didn't vacuum for 12 years was beyond ridiculous. 2. The asbestos dust was on a floor we installed 6 months earlier, included the receipt for the floor. And then the third point was the most fun to write. 3. I said they were welcome to believe the contamination was caused by the contractor who installed the previous system 12 years ago. I included the receipt of that installation. It was done by the same contractor. The next letter was very brief, stating they would pay us for all damages we were claiming. When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said to shake counsel. I still had to go forward, but we got off on the right foot and I ended up with an A. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said yes. In England, we don't say I rest my case. Instead, I looked up at the bench, said no further questions, and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The adder then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. IP lawyer. Deep in a set of terms and conditions on a website, our client's details, name and contact details were listed. So it is very evident that they just copy pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick CTRL+F for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. I had a client who, despite being a large man, had been domestically abused by his much smaller wife throughout their marriage. After the divorce, she turned her anger on their son. He ran away one day to live with his dad, and we filed to restrict her parenting time and for a permanent modification. At the permanent hearing, she denied being abusive to the child or my client in front of the child, said she never threatened anyone ever, and that she never made disparaging remarks about my client in front of their son. What she didn't know is that he had recorded multiple instances of her abuse, and so I called my client back up for rebuttal and played an audio recording of her screaming at my client, threatening to break his face in and calling him a loser, all while the child could be heard in the background asking her to stop. I looked over at the other attorney and she had her face in her hands. We won. It wasn't a trial, though we had one of those, and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks, i.e. notes he took during class. He is furious and sues the landlord in small claims for $5,000 state maximum because his notebooks have such huge value apparently. They hire me and I respond, which moves the case out of small claims. It's just the way it works here after time in r/legal advice. I know this is not the case for every state, but our rule is better than yours. But enough aside, this puts him at a huge disadvantage because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned. Period. End of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. This isn't my story, although I'm an attorney. It's my dad's. He was a federal prosecutor, and a few years ago he prosecuted a high-profile white-collar fraud case against a defendant that had essentially run a Ponzi scheme through a small investment bank in Ohio he had purchased. The fraud resulted in $200 million stolen from low to middle-class victims that had invested their retirement savings. The defendant, who was also an attorney, testified that he never did anything illegal, and the investment bank simply failed because of the downturn in 2008, which resulted in failed investments. My dad then played for the jury a recording from a wiretap the FBI had obtained of the defendant's cell phone in 2009. The call was a conversation between the defendant and his CFO. During the call, the defendant instructed the CFO to lie to investors by telling them the bank's computer system was down for a Jewish holiday, so the investors couldn't withdraw their money. The CFO responded, "Can't we go to jail for this?" The defendant answered, "Yeah, but no one is going to find out." The defendant was convicted on 12 over 12 counts. During sentencing, my father quoted Dante's Inferno, citing the fact that the bottom level of hell is reserved for grifters and fraudsters who know better but still take advantage of people. The defendant was sentenced to multiple life terms.